Good day everyone, my name is Jolibee Mabanglo, a student of BS Accountancy, and I'm making this video to make a reaction about the case of Diesel Corporation Company versus Jolibee Foods Corporation. So the facts, the evidence facts that the Diesel Corporation Company, which is the petitioner, appeal on court on December 18, 1991. Diesel Corporation, the petitioner, instituted before the Regional Trial Court of Makati, Branch 61, an action for the recovery of escalated construction costs in the aggregate sum of 4.3 million pesos, which it had allegedly incurred in the construction of buildings located in Batangas City and in the municipality of Calamba, Laguna, owned by the Respondent, Jolibee Foods Corporation, for the alleged failure of petitioner to complete these projects on time. Jolibee Foods Corporation counterclaimed in its answer recovery of damages and attorney's fees in the sum of 2.7 million. At the pre-trial, the parties agreed to reduce the issues to whether Diesel Corporation Company had completed the Calamba and Batangas City projects on time, and whether Diesel Corporation Company was entitled to escalate construction costs. After trial, the Regional Trial Court rendered its judgment dated May 13, 1997, ruling that Diesel Company Corporation had completed both projects on time and was entitled to escalated projects costs. The dispositive portion of judgment reads, whereof premises considered judgment is hereby rendered for the petitioner as against respondents is hereby ordered as follows. 1. First, for the Calamba project to pay petitioner, which is the Diesel Construction Company, the amount of 899,940 pesos and 45 cents with the interest of 12% per centrum per annum computed for the time of the filing of the case. Second, for the Batangas City project, the amount of 3,677 and 28 cents with the interest at the rate of 12% per centrum per annum computed for the time of filing of this case, to pay the sum of 400,000 as by way of attorney's fees and to pay the cost of suit. Contending that Regional Trial Court failed to order payment of extra work done by Diesel Construction Company, filed on July 14, 1997, a notice of appeal. On July 7, 1997, a motion for execution pending appeal in said motion. It is cited as a good reason its financial distress as a small business and to answer for damages Jolibee Foods Corporation might sustain by reason of the grant of the motion, the posting of bond equivalent to the 20% of the total amount due. Respondent likewise filed in this month's notice of appeal on July 31, 1997, and actively opposed petitioner's prayer for execution pending appeal. In special order dated December 4, 1997, the trial court nevertheless allowed the execution pending appeal on the finding that Diesel Construction Company was a matter of right entitled to the payment escalation of costs. Jolibee Foods Corporation appeal was interposed only to delay payment. Petitioner would pause a bond equivalent to 150% of the total amount of judgment. On January 16, 1998, Jolibee Foods Corporation filed a motion for reconsideration with an alternative prayer that it be permitted to cause supersedes bond pursuant to Section 3, Rule 39 of the Rules of Court. And its order dated March 19, 1998, the Regional Trial court denied the motion for reconsideration on the ground that the filing of counterband was premature. Diesel Construction Corporation had yet to file its own bond. In view of both parties' appeals, the trial court forwarded the original records of the case to the appellate court of the further proceedings. On August 12, 1998, Construction Company filed with the Court of Appeal a motion for issuance of premature writ of execution, grounded on the arguments that the special order of December 5, 1997 had become final and executory for the failure of Jolibee Foods Corporation to seasonably question its propriety, and Diesel Construction Company filed with the Court of Appeal a motion for issuance of December 5, 1997 had become final and executory for the failure of Jolibee Foods Corporation to seasonably question its propriety. And second, Diesel Construction Company was ready to file the required bond. In petitioner's own words, it was readily, willingly, and able to post a surety bond to issued by the Development Surety Insurance Company Incorporated in favor of Respondent, which is Jolibee Foods Corporation, in the sum of 10.6 million or equivalent to 150% of the judgment award, amounting to the 7,079,038 pesos and 7 cents to answer any damages that may be caused to respondent by the wrongful issuance. Therefore, in response to Diesel Construction Company motions, Jolibee Foods Corporation filed a comment with the motion to stay execution by the posting of supersedes bonds. As earlier adverted to the CA in a sealed resolution of September 21, 1998, directed to the regional tribunal the issue of writ of execution upon the petitioner posting of 10 million bond and to stay execution upon respondent's filing of a supersedes bond of 15 million. Diesel Construction Corporation filed a motion for reconsideration for the resolution insofar as it allowed a stay execution with the motion for the CA denied for a lack of merit in the which motion for the Court of Appeals denied for lack of merit in the question's resolution on December 22, 1998. The ruling of the Court of Appeals. In the first sealed resolution, the Court of Appeal ordered immediate execution because Jolibee Foods Corporation had failed to question by certiorari the special order granting it. However, as the liability of respondent was yet to be determined on appeal, the Court of Appeal granted a stay of execution upon the respondent posting of a superseded bond. In the second assailed resolution, the appellate court denied petitioner's motion for reconsideration of the stay execution because of attendant circumstances recited in the assailed resolution. First, respondent, which is Jolibee Foods Corporation, first addressed its motion to stay execution to the Court of Appeal, which considered it as premature because petitioner, which is Diesel Construction Company, has not as yet posted the required bonds. Secondly, by the time petitioner was ready to post the bond, the records had already been transmitted to this court. Petitioner filed with this court its motion for issuance of premature writ of execution dated July 28, 1998, and this probably prompted respondent to reiterate its motion to stay execution by posting of supersedes bond, having thus provided this court to act on its motion on July 28, 1998. It could not be prevent if not acting on respondent's motion to stay execution, which is but an offshoot of its own motion. The Court of Appeal also rejected the imputation of forum shopping It held that when the petitioner posted the bond, the respondent could not file with the trial court its own motion to post a supersedes bond since the record had already been elevated to the Court of Appeal. Hence this petition. The issues. So, in its memorandum, the petitioner raises the following issues. 1. Whether or not, under the Section 3, Rule 39 of the Rules of Court, an appellate court like the Honorable Court of Appeal has discretionary power to stay the discretionary execution issued by the trial court. Second, whether or not party in whose favor of discretionary execution was issued by the stop of attendant circumstances assailing the lack of authority discretionary power of the appellate court to stay the discretionary execution issued by the trial court. Third, whether or not the pendency of the appeal is just a proper ground to stay the discretion execution of a judgment under the Section 3, Rule 39 of the Rules of Court. Fourth, whether or not the holding of the trial court that motion to stay execution by the posting of a supersedes bonds is prematurely filed constitute a denial thereof. And fifth, last, whether or not the refiling of the immediate preceding motion with the Honorable Court Appeals constitute forum shopping. In its own memorandum, respondent raises the procedure issues of the whether recourse under the Rule 45 is power, immediately to question an order granting a stay of execution pending appeal. In some of the parties raises in the following issues whether a petition for review under the Rule 45 the proper remedy to question an order staying execution pending appeal, whether the Court of Appeal has jurisdiction to issue such order, whether stopped by petitioner from questioning the former jurisdiction, whether the pendency of an appeal opposing supersede bonds just stay and execute pending appeal, whether the respondent is guilty forum shopping. The court's ruling. We find no reason to grant execution pending appeal. So, in this case, my ideas, opinions based on the regulatory framework and legal issues, I find this case, for me, Diesel Corporation should not file a motion for reconsideration for asking Jolibee Foods Corporation to payment for extra works, because in this case they did not mention how much is that extra work is, and besides the regional trial court of Makati already granted his petition for the escalation of construction costs. So the regional trial court of Makati granted the diesel car construction company the amount of 199,940 pesos and 45 cents in the interest of 12% per annum, and for Batangas project amount of 3,677,28 cents. I think Diesel Corporation should not stay with that and did not ask for more, like asking filing a motion for reconciliation for the financial, or asking Jolibee Foods Corporation for them to pay. With this, I find it, the more they file for in a case, it more on, like they filed a case on 1991, and the ruling of courts was in 1998. It was 7 years before they got their pay. So, and the Court of Appeal, same with the Supreme Court, they have the same judgment, which is they did not grant the petition of the diesel corporation, diesel construction company, of their motion for the motion of reconsideration paying, asking to pay Jolibee Foods Corporation because they are a small company, something like that. So that's my opinion. So that's it. That's my course project for the subject regulatory framework and legal issues in business. So thank you.